What?
You asked me to read this right now.
Yeah, my mom just said it. She's like, that's mom.
It's in this.
Like,
Are you kidding?
no. My mom got that back, and then my mom reads it out here. She's like, already have them old ones. I put it in the I put it in the laundry room. I'm like, are you kidding me?
Could you even see us eating?
Well, I guess they could. See, we're going to push that session.
Oh. Kind of eye this one.
I don't know. I thought you just got eyelashes.
No, I think that I probably should just pull my contacts.
You got contacts? None of that, Jan. You just fork over the dollars and get the lace back. It's pretty.
I know, but you know what? You still have to have glasses to read.
No, it depends. It depends. Have you been checked out for that?
No, but my doctor who works for Updegraft, who does that, has never suggested that.
I think I'm thinking that maybe my 40th birthday gift to me.
Yeah.
I know, I kind of like wearing glasses, but I think it's really annoying.
I can't stand it.
It's really annoying.
What I hate is that I wear them in the morning on a walk. Is that it limits my whole field. It just seems like it's like the sky. I mean, I don't notice it here at work, but when you're outdoors.
When I wear my sunglasses, I'm noticing that because they're like really good on it. What? No glass.
Do they?
Hey, I remember. I said that like this.
Who said that?
Sorry, you could care less. No, but he's magnetic and fresh. Excuse me, but that street has try to have the longest uninterrupted drive. Go 24/7 so long. You go before you do that. I don't know.
What about the jury? You don't know a long run from the jury?
Yeah. Be good for a game. bombshells, mock. It's like boom's like permanent, unwavering, stuck, like rock hard.
Not gonna change.
I mean,
It means you think they're guilty right now, and you'll think that for the rest of your life. You won't wake up tomorrow and
that's
say,
an
"Well,
abiding condition.
maybe I was wrong."
If you don't have one or run the waivers, then
You think about it.
then you'd be like one day, 1 minute,
Sitting on the couch.
events, she's good, and then the next
Yeah, I got that one wrong.
yeah,
You know,
recriminations, you know, I'm wavering. At least the trial itself, yes, the judge is a little cantankerous in there. We got every major point we wanted to make. Even some of the things that look like we weren't going to get in, like talk of the press conference line, we finally got out. So there's nothing missing. So I don't know. Give it a draw. See what happens. Everyone would. Yeah, it's been 3 years. But your mom will help bring you back on this swing. And he's correct. Well, I think today we got the clearest glimpse of her yet. She wasn't behind or anything. It was good because she could speak clearly. And she admitted to some of the things that I really didn't think she could admit to. She could have been much worse. It turned out okay. Yeah.
All right. Circuit court is back in session.
Okay, so question number 2 is, should number 1 under 15.1 robbery, hold on, be taken literally, or if it is determined that Miss Me is a principal, would that apply? You all want to come up and look at what 15.1 is?
I do.
Yeah. Just you don't take it down yet, they're just looking, it's like pretend they're at their tables for now, and then they can make their... I have 2 copies of instructions if you need a second one to look at.
Oh, really? It's a long question. How did that happen? Oh, in the same case? Wow.
Do you mind?
No, go ahead.
Here.
I just need to look at them together.
Wait, that's the other copy of that. Yep. Mm-hmm. It was written better this time.
Yeah.
Mm-hmm. Well, it took them a really long while to write the question, because we were waiting that whole time for them to write that, yeah, so, because as soon as they left, they said they had one, but it took
You want to
them...
look at it for a minute? I'm still...
So they basically want to know, yes. So it looks to me, in reading the question and the instructions, that what they want to know is if principle applies to the robbery.
Correct. Legally, it does.
Correct. So I don't think it would be right to tell them that you don't take 15.1 literally. I don't think that's the correct answer, even though that's the way they state it.
Right.
But principle applies to robbery.
I think this is going to cause potential confusion. I would request that it be answered exactly the same way it answered the first question.
Okay, well, I think we're supposed to, and it's 35 years ago when I started, you were supposed to say nothing to anything. Now, they give us much more direction about answering questions. There's jury instructions about asking questions during trial. So, I am protecting you by not answering it yes or no, you don't take 15.1 literally. I think that's inappropriate and would work against the defendant. But it would be a misstatement of the law if they thought principle did not apply to robbery. So I would not be willing to answer the entire question because I don't want to tell them, I'd rather not comment on 15.1 being taken literally. Do you understand?
Oh, I understand.
Or I can say, yes, you can take it literally, but it must be read along with the principal instruction. So you can choose between those 2 choices if you'd
Wouldn't
like.
the least harm, though, be to rely on the instructions as previously given? I think if we start trying to bifurcate it,
I'm not trying to bifurcate it.
or try to answer it, it opens potential issues for appeal. I think by answering it in the manner that you've suggested would be essentially virtually instructing them to find her guilty.
No, it's not. The principal instruction applies to all of the charges. It applies to accessory after the fact. It applies to manslaughter. It applies to murder in the first degree.
Absolutely.
So they're just asking, the part that's I don't really want to answer is, should number 1 under 15.1 robbery be taken literally? But if you want me to say yes, but it must be read in conjunction with the principal instruction, I will do that if you like that better. The question is, should number 1 under 15.1 robbery be taken literally, or if it is determined that Miss Me is a principal, would that apply?
I don't like either option. If we have to have a choice between the two,
Well, I mean, make another choice other than not answer it at all. I mean, some questions I can't answer at all. The last question I knew I couldn't answer at all. I just had to have you here because that's the rule, but I knew what the answer had to be. So, if anybody else has another suggestion, I'm happy to listen to it.
Yeah.
I forget what we did in our other trial.
The principal statute applied to the property.
That's what we said.
Okay.
The question was also worded a little differently. It wasn't that literal form.
So if you want to look at that and make another suggestion, that's fine. Mr. Camerino, you're welcome to participate.
Please,
This is like,
I feel like the lone wolf there.
well, I don't think you're the lone wolf. We're just trying to answer a question to the extent we can, if we can do that without prejudicing anybody. And you don't want a question answered because
I
you...
think it'll prejudice or against our client. I mean, there's nothing improper or error if you respond to the first question, correct? We're not doing anything wrong.
Right.
I would say that's...
I'm not telling him to find him guilty, but it would be a misstatement of the law to suggest that the principal instruction doesn't apply.
Well, I'm not saying you do that. I'm just
Well,
saying
but
they
you're-
answer it at all and say rely on your recollection, which is the safest, least prejudicial route to take. If we start trying to answer part of it,
Okay, then tell me how I answer the whole thing. I offered you multiple options.
is exactly as you had stated in the first question, that our response is that you should rely on your instructions in the law as previously given, to that effect. To me, that seems to say that's not going to resolve any appeal issues. It's not steering them in any one direction.
I don't plan to steer them in any one direction. If I can clarify the law for them in a way that does not misstate it, and they ask us a specific question, I think it's my job to do that. I'm asking for your input on the best way to do that. I don't pretend to have all the answers, but they're asking for specific clarification. You know, and that new jury instruction even says, I will answer any questions if I can in writing or orally here in open court. So,
Clarify our position. Again, we would say this answer would be that we would rely on their recollection and instructions provided, and that's in the package. Anything beyond that tends to spotlight where you have answered. I understand the court might not agree with that.
I don't think it's the same as 35 years ago. I think if I can answer a question without directing them in a direction, I should answer the question. I don't blame you for making the suggestion you're making. I would make the same suggestion if I were you doing your job. My job is to try to answer the question, if I can, in as neutral a fashion as I can, and assist them in understanding the law. Like giving them a new definition from Webster's dictionary is not following the law. Telling them, so, the question is, should number 1 under 15.1 robbery be taken literally, or if it is determined that Miss Me is a principal, would that apply? So, I can say, for instance, the statutes are to be taken literally, and the principal statute applies to all of the charges. So, I've given you the part of its... Yes?
I don't want to irritate the court.
You're not going to irritate me. It's just, if you have a logical, legal objection, make it. If you have another suggestion, make it.
So
But-
the court is not inclined to tell them that they should just rely on
If both sides think that's what I should do, then I would probably do it even though it's not the answer to the question. Is that what you think I should do?
No.
Okay, and what do you think I should do?
I think that we should advise the jurors to the law that the principal statute applies to the robbery.
Okay. And you would probably prefer that I didn't tell them number one, or that the statute should be read literally, correct? Because that doesn't help you. But I would be willing to do, like I've said multiple times, both sides of it, say all of the instructions are to be read literally, and the principal instruction applies to all of the charges.
Maybe if without waiving, this is an idea, Judge.
You don't have to waive anything, but
Provided that the elements of the principle.
See, that's exactly my concern. By saying that the principal instruction applies to all offenses, I'm not sure that's really quite accurate. In one sense, it is available as the jury deliberates to see if the elements of principle are met. But I think if you're going to go that far, you would then have to
Mr.
say,
Trevina, it was listed in the indictment. They're entitled to go on a principal theory. They've said they are going on a principal theory. I must, by law, give the principal instruction. They can choose to read things how they wish to and apply it to the facts how they wish to. But it would be a misstatement of the law to suggest that the principal instruction doesn't apply to all the offenses and the lesser.
then my next position would be the next stage is we read the principle in 15.1 straight from the jury. That way, there's no danger of contamination of any kind, misinterpretation of any kind. You don't have to worry about the wording. Just read the law.
Answer the question and then reread the law, or just reread the law?
Just reread the law.
I don't think that answers the question.
I hope it answers the question.
No, it doesn't. And see, in the old days, they didn't get a copy of the instructions. And I give them, they have 12 copies of the instructions. Okay, thank you. Let's bring them in.
Thank you. First to Lloyd. Bring him in, Lloyd. Yes, please. Judge, the jurors are present and seated in the jury box.
Okay, Mr. Domedian, the second question is, should number 1 under 15.1 robbery be taken literally, or if it is determined that Miss B is a principal, would that apply? And the best answer I can give you is that all of the instructions are to be taken literally, and the principal instruction applies to all of the charges. You're welcome.
Judge, the jurors are adding in.
Thank you.
All right.
Your Honor, before,
To the call to court.
just for the purposes of the record, Judge, I would like my objection noted. I would also at this time move for a mistrial based upon the court's instruction to the jury over our objection.
Very good. Your motion for mistrial is denied.
Thank you, Your Honor.
Stay right there. Oh, yeah. That's very good. Okay. I asked the door. Thank you very much. I appreciate it.
I misstayed you and pushed me. Oh. Because you were walking down there with the, okay, so you with the meeting? Got you.
Two of those guys. Huh? Almost. I'm telling you. And then she stopped.
First to building security. Our second question has been taken care of when we are back deliberating.
Well, I guess I'm going upstairs. It's freezing back here.
Okay, see ya.
Hopefully soon.
Hopefully so. Yes. Hopefully you don't get back there and get hung up now.